Calling the third case, which is case number 167705. This is People of the State of Michigan versus Kristopher Joesel. This is a mini oral argument on the application, each side having 15 minutes of argument. Again, you may reserve time for rebuttal if you'd like. Just we ask that you keep track of it. And you both will have 2 minutes of fire-free zone that you may waive. But proceed when you're ready.
Madam Chief Justice, may it please the court. My name is Britt Cobb. I'm very pleased to be here on behalf of the appellant, Kristopher Joesel. I will try to reserve 2 minutes for rebuttal. Going all the way back to the 1862 decision in Mayer, the court has said that it is the jury, not the trial judge, that decides a heat of passion claim to mitigate murder to manslaughter. The judge has discretion to decide admissibility of evidence regarding provocation, but when evidence of the provocation is admitted and a rational view of that evidence supports heat of passion, the judge has no discretion. The manslaughter instruction must be given. In this case, the evidence here was that the decedent twice chased down the defendant, pursuing him to confront him. Both times, he retreated and tried to disengage. The evidence was that she yelled at him, she assaulted him, slamming him into a wall, causing him to cut his hand. And the evidence was that he was fearful, surprised, and immediately reacted. And because a jury could reasonably conclude from all of that her pursuit and her assault of him stoked his passions, it was error to refuse the manslaughter instruction. Now, we are not asking the court to test sufficiency here. This isn't a motion for a judgment of acquittal.
Counsel, how do you account for all the other activities that took place in the evening that led up to this?
Well, Your Honor, the activities that led up to it were not the provocation. The provocation was her assault of him. And I think that when we're dealing with what you're asking about, Justice Bernstein, we're talking about sort of about that middle part. You know, was he acting out of reason versus passion, or was he the one escalating the events? At this point in the night, he was the one de-escalating the events. And while I think that it's perfectly appropriate to take the whole continuum of events and argue it to the jury, when we're talking about whether the jury gets the instruction, we have to look at the rational view of the provocation, the cooling off period, and whether he was actually acting in heat of passion. So I do not.
So Ms. Cobb, it's sort of echoing what Justice Bernstein was asking. If we were to agree with you that the instruction should have been given, then we of course have to do a harmless error analysis, at least as the law stands right now. So. And we get into this, what is a rational view of the evidence? Understood. The jury obviously had all of the evidence, to Justice Bernstein's point. And so your argument is, do we just essentially look at the moment in the apartment vestibule? Is that it? We don't look at everything when we're doing our harmless error analysis?
No, I think you can look at all of the evidence that came in. But when we're talking about the adequacy of the provocation and whether he acted out of passion rather than reason, I do think you have to isolate the moment of the provocation. Because he was trying to de-escalate and disengage at this point, regardless of what had already gone on in the middle of the night or earlier in the night. And this isn't a scenario where we are looking at this, in the light most favorable to the prosecution, because this isn't a sufficiency argument. It's an argument about taking a rational view of the evidence that was presented, all of it. And the fact is that the defendant's testimony established each element of heat of passion. And having established that, it was error not to give the manslaughter instruction. So I guess let's talk a little bit about the different standards of review, because I do think that there are different stages of this. I've already touched on one of them, which is, of course, the trial judge has discretion to exclude the evidence of provocation if, as a matter of law, it finds that no reasonable juror could find that the provocation was adequate. We're not, that's an abuse of discretion. That's like every other evidentiary issue the court has to deal with. And we're not dealing with that here because everything came in. Nobody objected to any of that coming in, so it was all in the record. So, but once the evidence is in and we move on to the next question, which is whether the admitted evidence supports the instruction, the reviewing court will look at the entire record de novo as to whether a rational view of the evidence supports the instruction. There hasn't been any deference given to the trial court. Reading the court's decisions in Pouncey and Mendoza and Cornell, the review has all been de novo to determine if the instruction is supported. And then because manslaughter is a necessarily lesser included offense, the instruction must be given if supported by the evidence. It's an error of law not to give it, and it's reversible. So then to Justice Welch's point, we have this specter of harmless error. I think it will be a rare situation where a rational view of the evidence supports manslaughter, but a refusal to give it is harmless, especially in a scenario such as this that I've already touched on, when the defendant's testimony establishes each of the elements for heat of passion, because the court has stressed in prior cases the importance of giving an instruction that is consistent with the defendant's testimony and allows the jury the option to convict based on that testimony. That's in the court's Richardson case. So it may be that this type of error, just is never, it can't be harmless. But even if it is, I think that the court need only look to its prior decisions in Yeager and Cornell, because it has said that the reliability of the verdict is undermined when the evidence clearly supports a lesser included instruction. And the reason that that's true is because it's impossible to know what a jury would do if it had been properly instructed. And that's, that the court visited this recently in great detail in Yeager. And I think that you have to look no further than Judge Mariani's dissent from the Court of Appeals to see that a rational view and the evidence clearly supported the lesser included instruction. Now, because the court will review de novo this sort of rational view question, I do want to talk about each of the three the three prongs of the heat of passion claim. Adequate provocation. For starters, I mentioned the 1862 Mayer decision. It stated in that case all those years ago, passion excited by a blow in a sudden quarrel is adequate provocation. Withholding manslaughter from the jury has been found in very, very few circumstances. Mere insults or the verbal fracas from Pouncey is one of them. Property damage cases, obviously, are a different category. And then, of course, when the provoked action was not the cause of the fatality, that's the Mendoza decision. But the jury gets instructed on manslaughter when the provocation has been simple assault. There are a couple of Court of Appeals decisions where that has come up, Roper and Oster. Of course, the aggravated assault situation in Yeager, and even, a threatening chase in the Court of Appeals decision in Neal, as well as infidelity. Those all are things that can be adequate provocation.
So is every, one of the things I believe the prosecution brought up is that essentially every dispute where I guess someone gets pushed or something and then the defendant claims, I was super upset, that manslaughter, the manslaughter instruction is always required then?
I don't know that it would always be required. You'd have to look at the facts of the case. But in this case, I know it gets referred to as a push or a shove, but hopefully you guys have looked at the video. It's an assault. It's an aggravated assault where a smaller person used enough force to slam a larger person into a wall and he cut his hand. And I think...
Okay, give you it's more than a shove, but what are we to make to the 3 lunges with the knife? Twice into the heart, or once into the heart, once in the femoral artery, and a 3rd lunge to try to make a stab.
I believe it was 2. I could be wrong with, but
Two actual stabs and a lunge a 3rd time.
Yeah,
That didn't penetrate the victim.
That was the passionate reaction, and this.
Doesn't it have to be reasonable, though?
I think that where the reasonableness comes in, Justice Zara, is on the self-defense aspect of things, whether you reasonably believed you were in danger of death or serious bodily injury. I think that what's required for the heat of passion is just that you are acting out of passion rather than reason without time to cool off. It's not a pass. This isn't an issue of an acquittal. It's an issue of reducing the level of homicide from murder to manslaughter. And that's, I think, where the difference
is. The reasonable is that the action has to cause a reasonable person to act out of passion.
That's true. That's true.
That's what I was focusing on.
Yes, I do agree with that.
And I guess when does it stop? Does it stop? Is it just the push? We'll call it a push. We'll call it a violent push, even for your sake. Or is it the response that comes with it? When do we stop looking at whether it should be something presented to the jury?
Well,
if you had jumped on the victim and stabbed another 10 times, would that make a difference? Or is it simply, what is the response to the violent shove?
I think that the focus has got to be on whether the defendant acted out of passion. And all of the things that you're talking about will go into the bag of tricks for the jury to consider. Remember, I think, and I could be wrong about this, but I think Yeager might have shot 17 times, So if we're talking about, those things needed to go to the jury.
Was he acting out of passion when he slashed the tires in the parking lot?
I'm sorry?
Was he acting out of passion when he was slashing the tires in the parking lot?
He was acting out of anger, yes. So the other thing I just want to touch on, I've got about 15 seconds left before the 2-minute mark, is the issue about the restitution. I would ask the court not to accept the government's invitation to read in this extra statutory right to restitution for lost future earnings. I think that the court has kind of dealt with this issue pretty square on in the Daher decision recently. When we have damages, I guess for lack of a better word, that are purely a creature of statute, the legislature certainly knows how to list out all of those different things: lost future earnings, loss of sport, loss of society engagement, and they are just simply not in the victim's rights statute, and we'd ask the court to reverse on that issue. Thank you.
Thank you.
Good morning. May it please the court. Heather Bloomquist on behalf of the people of the state of Michigan. Not every hot-tempered individual who flies into a rage at the slightest insult can claim manslaughter. This court set forth that principle in Pouncey, and the trial court abided by it in the proceedings below. After watching the video of this killing and hearing the defendant's own testimony, the court was left with no option but to conclude that a rational view of the evidence did not support giving the manslaughter instruction. The defendant, and many of these facts have been pointed out in the court's questioning, the defendant, larger, stronger, and armed with a tactical knife, responded to a simple shove in the back by driving a blade through the victim's ribs, into her heart, pulling the knife out, thrusting it again into her, severing her femoral artery, and then attempting to stab her again, but missing. As the victim was bleeding profusely, the defendant, as the video showed, was calm, and he was having full control of his faculties. The video, and I implore the court to view it if it has not done so already, shows not a man acting out of passion, but a man who is acting with reason and control of his faculties. This action by the defense was not passion. This was not adequate provocation. Michigan law does not permit such brutality to be mitigated to manslaughter. And when we look more closely at the standard for manslaughter, the record confirms there was not adequate provocation. And I think this gets to Justice Bernstein's point is we cannot look at this in a vacuum. All of the facts from that night are relevant. And yes, the defendant wants to isolate the simple shove, but that I think would be neglecting very relevant evidence that's very important in this matter. The fact that this defendant had committed multiple felonies and was retreating after he's being confronted by individuals who are on the phone with 911 and an individual who's trying to stop him. I think that that is an absolutely critical fact for what then happens in that vestibule and as to adequacy of the provocation.
Counsel, how would you differentiate this case from our decision in Yeager? How would you work around Yeager?
Thank you. So as I was preparing for this and watching the court's oral arguments on Yeager and reading through the case, what strikes me is almost looking at that case and this one, the defendant's actions in this case were absolutely the one of being the provoking party. And I think that is a key distinguishing factor from Yeager, where we have a defendant who is the one escalating situations step by step by step and creating the circumstances. Now, in Yeager, and again, I know there's a distinguishing fact that that's an ineffective assistance of counsel umbrella that was reviewed under, but nevertheless, the defendant in that case was the one who was sort of on the, for lack of a better term, the receiving end of the escalation of that. She had been brutally hit multiple times. She'd been dragged out of a vehicle by her hair. She then, so there's other factors there that occurred. In this case, the defendant had no interactions with the deceased up until that moment in the vestibule, or until physical interactions with her. So I think that there are very key factual distinctions in this case from Yeager. And with that, I think ultimately comes the people's point here is that the law cannot reward the loss of self-control, and it encourages restraint, which then gets to the point that this is an objective standard of reasonableness when we're looking at the defendant's claim of adequate provocation. Would a reasonable person react in the way the defendant did under these circumstances? And I think as a matter of law, and that's what the trial court found and the Court of Appeals necessarily found, is this was not something that an objective standard of reasonableness would support in granting this instruction.
Counselor, there was a self-defense instruction given in this case, right?
Correct.
And so the court believed that there was enough evidence that the defendant honestly and reasonably believed that he was in danger of being seriously injured, even if that's later wrong. And so I'm struggling to see how there's sufficient evidence of that honest and reasonable belief, but not sufficient evidence for manslaughter. Could you square that for me?
Yes, thank you, Your Honor. Now, in order to give a manslaughter instruction, there must be heat of passion as well as adequate provocation. So I think the court's question and focus on self-defense goes more to the heat of passion aspect of it, which is those thoughts that are inside, that are intrinsic to the defendant and his actions. That is more encompassed by the self-defense aspect of it, is the heat of passion element. But what the court ultimately found in the proceedings below was that this was absolutely not adequate provocation. That was the ultimate ruling, and I think that's how we can square the ruling to give self-defense but exclude manslaughter. Now, there is one other point that I would like to address that Sister Counsel raised, which is the standard of review. And respectfully, I disagree with her as it relates to what the standard of review is here. And specifically, well, ultimately, the question of whether to give a jury instruction is a de novo review. The trial court's findings of fact as to whether or not the rule itself is applicable is for an abuse of discretion standard. And I think that that's the appropriate standard to hear, because when we have a trial court that is sitting and hearing the evidence, particularly that of the defendant, and reviewing the evidence through the trial, I think that those findings of fact as it relates to the giving of the instruction should be reviewed for an abuse of discretion. And I do believe it's People versus Dobeck that's cited in my brief for that standard of review. So with that abuse of discretion standard, though, the trial court did not choose a range of outcomes that fall outside of reasonable and principled outcomes here with denying the instruction. And ultimately, the defendant's request here, and particularly what's been argued here today before the court, would obliterate the gatekeeping function of the trial court in whether or not the evidence as presented would warrant the instructions. This is almost a per se rule of, well, you get manslaughter without reviewing, what the facts are and the presentation before the trial court. You ask for manslaughter, you get it. And that's not what Yeager says. That's not what the precedent says in this case. And it actually is, I believe, Pouncey, where Pouncey stresses the importance of the gatekeeping function of the trial court. And the trial court properly engaged in its gatekeeping function and made sure that the evidence, if it fit, would have given the instruction, but it didn't. And so the trial court did not.
Counselor, could you address harmless error? So imagine that we believe that the instructions should have been given. Then what analysis would you have us take?
Yes, thank you. And I do think that the Court of Appeals engaged in this, and I would echo what it says, but factually in this case, there's a unique circumstance that occurred in the instructions, and I think it's one that's a little unusual, but it absolutely factors into this harmless error analysis. In the malice instruction for second-degree murder, the trial court actually partially read that, and I can quote it here, but the court said that in order to find, here we go, I'll quote it just so I'm not misrepresenting anything, but third, that the killing was not justified, excused, or done under circumstances that reduced it to a lesser crime such as manslaughter, which occurs if the defendant acted out of passion or anger brought about by adequate cause and before the defendant has a reasonable time to calm down. So specifically, the jurors were instructed as to that for the malice element of second-degree murder. And artfully, opposing counsel in her closing, very, very eloquently, if I may, she hit on that, and she said, it might be something, but it's not murder, and murder's all you have before you. And I think when you look at the instruction as given, if the jurors would have actually contemplated adequate provocation and heat of passion and manslaughter, what would have happened is they would not have found beyond a reasonable doubt that malice element for second-degree murder, and they would have acquitted. So I think harmless error in this case is it's very fact-specific to this case, given what was instructed to the jurors. But I do think that that is absolutely why the decision to exclude the full manslaughter instruction would not affect the outcome of the proceedings below. Okay, and just continuing on here, I do want to also challenge a couple of factual assertions here that this was somehow an aggravated assault. And my recollection of the record is that while the defendant's hand might have been cut, I don't believe that the record would support that it was the shove from the victim herself that caused the cut. And I don't recall this testimony necessarily saying that. I would submit to the court that this is a simple assault. But even further, as I've already stated, we have a defendant who has been in a 30-minute state of simmering rage, as the Court of Appeals has categorized it, and he is fleeing a location in which he has committed multiple felonies, property damage, carrying with unlawful intent. And I would assert that, as the Court of Appeals noted, that to constitute adequate provocation, a battery must not have been privileged, and it must have been a hard blow, inflicting considerable pain or injury. Here, I would submit to the court that the touching by the deceased in this case was not necessarily an unprivileged touching in trying to stop this individual from fleeing this location while authorities are being called. And I think that factors into this importantly.
So counsel, what, in your view, what facts would have had to be present to justify a manslaughter instruction here?
Well, Your Honor.
What would have been different that would have justified it? I'm trying to figure out where the line is, when we include it and when we don't.
Yes, Your Honor. I think that in this instance, if we were to strike out everything that happened up until that vestibule, and we have, let's say the defendant is walking into his apartment, and he has not created this situation out in the street, and he is shoved in the back by an individual who is the same size and strength as him, who's also armed, I guess in similar footing as him, and he then reacts. I think that would be a more clear situation. But here we have the evidence that the defendant observed who was in the vestibule with him. The video would show that he's had eye contact with her. They exchanged some words, and there's that. This situation where the defendant is the provoking party does not rise to adequate provocation when he creates the situation that he then claims he is provoked from. And I know I argued.
So, Counselor, what do we do with Reese? So Reese says that our court we don't have an imperfect self-defense as such, but certainly it suggests that you can be the initial aggressor and still obtain a manslaughter instruction.
And I don't disagree with that, but I think that as many of these cases as it relates to giving of the manslaughter instruction, it is all highly fact-specific. And I think the facts in Reese are distinguishable from the facts here. I think when you're looking at what the defendant did and how he was acting, and particularly, and I don't recall in Reese, I don't believe there was video evidence of the defendant's actions at the time of the shooting. I would be surprised because I think it's a street. He's out in the street. But here, you have video up in the vestibule and in the hallways of what the defendant's demeanor is, how he's acting. And so I think it's just a fact-specific inquiry that this case, this is not the case where it satisfies what must be shown to get a manslaughter instruction.
Counsel, I just want to turn to the restitution issue. I'm just asking truly about your experience or the prosecutor experience generally. Is this a new thing that we're dealing with? Or is this sort of a departure from how restitution has been done in the past, or is this a common sort of these future lost wages? Is that something that's commonly assessed under the Crime Victim Rights Act?
Your Honor, in my experience specifically, this is an unusual restitution request and order, but given that it's unusual doesn't mean that it's not supported by the statute. And it's my position that the plain language of the statute fully supports the court's authority to grant restitution. And I do want to just put a fine point on this issue. That is ultimately what was challenged in the trial court, was the trial court's general authority to grant this type of restitution. There was no challenge to the calculations of it, and so any claim now that they were improperly calculated or it's too difficult to ascertain, that's not properly before the court, because what was before the court is the trial court's general authority to grant restitution. And it's my position, I know I'm running low on time, it's my position that the statute clearly contemplates this sort of restitution to make it complete and maximal, and that's particularly so when you look at the plain language of the restitution statutes and the Crime Victims' Rights Act. If the legislature did not intend this, they would not have included the actual phrasing, lost wages and victim's estate, which necessarily contemplates post-death restitution for this. And I want to thank Your Honors for the time, and thank you.
Thank you.
There is no case that has approved of this type of restitution. And yes, we do challenge the court's general authority to impose this lost future earnings. So it gets de novo review, and it is not covered in the statute. There's also no case.
Counsel, what do we do about our decision in Garrison?
I'm
We have a decision in Garrison that basically said the statute's maximalist, you can add more than's actually listed in the statute. Would we have to overrule that if we were to agree with your position?
Is that, and I'm not familiar with the case, so is it specific to the CVRA or?
Restitution, yes, it is.
Well, I don't think you have to overrule it because this doesn't, the statute can be maximal as it relates to what is listed, and then the goals of restitution, which are to make whole and not provide additional damage beyond that which is actually lost. And there's also no case where there has been assault, whether simple or aggravated, where a manslaughter instruction hasn't been supported. I do believe this was an aggravated assault. He did testify that he cut his hand during the assault. And I see that I'm out of time. Thank you.
Thank you. The matter will be submitted.